charged with trying to cover it up, obstruction of justice charges. So there's a lot more. This is chapter 1 in the Timothy Coggins saga. We'll make sure to update you more about this case here on Law and Crime. But as I said, that's not the only case that we got a verdict in. As you know, we were carefully monitoring a case out of Kentucky, a Marine killing case. Jonathan Price was gunned down on the night of his wife's birthday outside of a bar in a parking lot. His wife was shot through the leg, survived. 2 men were on trial for the murder of Jonathan Price and the attack of his wife. Quincinio Canada and Dewan Malazim, an uncle and nephew team. They were also charged with robbery, 3 counts of robbery that occurred 6 days before this shooting at a Quality Inn. It's believed that they had taken a gun from one of the victims at the Quality Inn, and used that gun to kill Jonathan Price 6 days later. So they faced multiple charges in connection with 2 different crime scenes. What did the jury come back with in that case? Let's play it for you right now.
Matter of Commonwealth of Kentucky versus Quincinio Canada, case number 15 CR 00592-001. As to count 1, we the jury find the defendant, Quincinio Canada, not guilty. As to count 2, we the jury found the defendant, Quincinio Deontay Canada, guilty under instruction number 10, first-degree robbery, principal, or complicit. As to count 3, we the jury found the defendant, Quincinio Deontay Canada, guilty under instruction number 13, first-degree robbery, principal, or complicit. As to count 4, we the jury found the defendant, Quincinio Deontay Canada, guilty under instruction number 16, first-degree robbery, principal, or complicit. As to count 5, we the jury found the defendant not guilty. As to count 6, we the jury found the defendant not guilty. As to count 7, we the jury found the defendant not guilty. As to count 1, the jury was unable to reach a unanimous verdict. As to count 2, we the jury find the defendant, Dewan Malazim, guilty under instruction number 10, first-degree robbery, principal, or complicit. As to count 3, we the jury find the defendant, Dewan Malazim, guilty under instruction number 13, first-degree robbery, principal, or complicit. As to count 4, we the jury find the defendant, Dewan Malazim, guilty under instruction number 16, first-degree robbery, principal, or complicit. As to count 5, the jury was unable to reach a unanimous verdict. As to count 6, the jury was unable to reach a unanimous verdict. As to count 7, the jury was unable to reach a unanimous verdict. As to count 8, we the jury find the defendant, Dewan Malazim, guilty under instruction number 27, complicity to tampering with this.
Okay, let's break that down. Dewan Malazim and Quincinio Canada were both found guilty of 3 counts of robbery at that Quality Inn. However, Quincinio Canada was found not guilty of the murder of Jonathan Price, not guilty of the assault of Megan Price, and not guilty of the robbery of both Jonathan and Megan Price. Dewan Malazim, the jury could not reach a verdict in terms of the murder of Jonathan Price or the assault and robbery of Megan Price or the the robbery of Jonathan Price. He was also found guilty of one other charge of tampering with physical evidence. So the question becomes, what happened here? Why did they find guilty on certain counts, not guilty, or hung on other counts? Let's bring back in Yosha Gunasekera. What why, if they were a team, why would they find Canada not guilty of the murder or anything having to do with the prices, but have a hung jury in terms of the Dwan Malazam?
I think really what was happening with the prices is I believe that the jury was having issues with the lack of evidence that the prosecution had. Now, there was a lot of things, standard things, that the prosecutor should have been doing, that the police and the detectives, evidence that they should have been gathering. For instance, there wasn't surveillance footage taken where there could have potentially been surveillance footage.
Well, we knew Dwan Malazam was in the area. He was in the Price area about 13 minutes before the attack occurred. He was at a liquor store.
Exactly, but being in the area is not being at the scene of the crime. I mean, there are simple steps that you can do. That you can test the DNA under the fingernails of Mr. Price, and that wasn't done. So I think those are all reasonable doubt, and the prosecution doesn't get a pass for not preserving evidence. And
do you know why they would have found, why didn't they just find Dwan Malazam not guilty? What was it that they were uncertain about with him that they were certain about with Mr. Canada? They said Mr. Canada was not guilty of anything to do with the prices.
I think it's because Mr. Canada wasn't in the area at all. I think there was more things that connected Mr. Malazam to the Price's murder than Mr. Canada. And the issue that it came down to, it's interesting that they had a hung jury because it's possible that there was a lot of people who thought that Mr. Canada was not guilty, also agreed that Mr. Malazam was not guilty. It could have been just one person who thought there was a shred more evidence for Mr. Malazam than for Mr. Canada.
What happens to Malazam now? Are they going to retry him on those counts?
I strongly believe they will retry him. Generally, when a hung jury is found on these very, very serious cases, the prosecutor is going to try to take a second bite at the apple, and they're going to know a lot more about the weaknesses in their case and try to build a stronger case the second time around. But I think we can guarantee and see another trial against him.
Okay, we'll have to wait and see, and we'll always keep you updated here on Law and Crime. Those were the two verdicts that were announced yesterday. Now it's time to get into our live trials of the day. As you know, yesterday we started a new case out of Florida. Two men, Kwame Richardson and Henry Hayes, have been charged with the murder of 22-month-old Aiden McClendon, a young boy. I want to show his picture if we have it up. I really want the viewers to really see the innocence of this young boy. You see him right there. He was gunned down from an alleged gang-related shooting. These two men are allegedly part of a gang, and they had a beef with another rival gang. They entered into a drive-by shooting, and this young boy was caught in the gunfire, was caught there, in the crossfire, excuse me. Really horrible situation. His mother testified yesterday. She had to recount the horrific nature of this scene. Her grandmother, his great-grandmother, also testified. The defense tried to poke holes in their testimony. Interesting note I have to make about this case. There are two separate juries, one for Richardson, one for Hayes. At points during this case, one of the juries will sometimes leave the courtroom while the other jury remains. That's why you have two separate trials in one. And in fact, one witness pointed the finger at the mother of this young victim pointed the finger at Henry Hayes as the shooter, but did not identify Richardson as the shooter. So you can see how this back and forth is going to happen, and perhaps both of these defendants may not receive the same charge. They might not receive the same verdict in the end, because you have these witnesses who are seeing two different things. They're represented by separate counsel, and they have separate juries. It's an interesting case to follow, and we're going to cover it here on Law and Crime. As soon as we have a live feed, we'll make sure to go to it. But I also want to preview another case that we're covering as well. We covered a little bit of it yesterday. It is a bizarre case, a horrific case about a young girl who was 17 years old that met a young man on a dating app, was lured out one night, and was killed. She was killed. She was strangled, and it's allegedly her head was dunked in Lake Michigan. It's a really horrific case. We have a short report about it. It is the case of Daniel Tate. He has been accused of killing Olivia McKay. Let's play you that short report right now.
Law and Crime now takes you inside the trial of the 2017 murder of a teenage girl underway in Wisconsin. 20-year-old Daniel Tate's accused of choking and drowning 17-year-old Olivia McKay in Lake Michigan. The two had met online. Tate's alleged to have arranged to meet McKay in a park in Kenosha County, Wisconsin, along with a friend. After Tate killed her, prosecutors say, Tate and his friend put Olivia's body in the trunk of her car and dumped it in a rural area. Much of the state's argument in charging Tate comes from a confession of that friend, high school senior Jamari Cook, who claims he was there when Tate met with McKay and watched him murder her. Cook's expected to testify for the state, but the defense says he's not credible. Prosecutors say the defendant, Tate, had a history of choking women during sex and may call 3 witnesses who claim Tate choked them during consensual sex. Daniel Tate's charged with first-degree intentional homicide, hiding a corpse, and taking a vehicle without consent. I'm Dan Abrams for Law and Crime.
It's our very own Dan Abrams reporting on this case. What a case it is. And so what can we make of it? Let's bring back in Yosha Gunasekera. This is unique. You have a defendant who's now pointing the finger at his co-conspirator. So Jamari Cook is allegedly going to testify, allegedly said that Tate was the one who killed her, and he just stood by. The defense really poked a hole in that and said he had the opportunity to kill this young woman. This is a unique case.
So a lot of this case is going to rise and fall in the testimony of Mr. Cook and whether he's credible. On one side, he can just say, you know, I saw it. This is my testimony. I'm truthful. I have no reason to lie. The other man, Mr. Tate, has a history of choking women. I'm just telling the truth. Or you could look at it as the defense is trying to present it, that Mr. Cook is just trying to save his own skin. Mr. Cook could have been the perpetrator, but in order to not go to jail for the rest of his life, he's going to point the finger at Mr. Tate.
This back and forth is very interesting, but that's not the only interesting point. As Dan explained in that report, they are going to be able to bring in prior incidents of Tate choking women during sex. How is that allowed in?
I'm a little surprised by this decision because some judges I could see saying that this is highly prejudicial. It's more prejudicial than probative, which essentially just means it's going to be more unfair to the defendant than it is going to give light and shed light to the jury. But it is coming in and it's going to be very damaging. One of the ways that this type of behavior can come in is a common scheme or pattern. It's one of the acceptable ways to bring in things from outside a trial in. So that's probably why the judge allowed it in, and it's definitely going to be very damaging.
Well, as another case that we're following here on Law and Crime, there's a lot to report on it. As soon as we have a live feed in that case, we'll make sure to go to the courtroom. Now, before we begin any of our live trials, here are the top crime stories of the day here on Law and Crime.
Here are today's top crime stories trending on lawandcrime.com and across the country. A former prostitute who was convicted in the death of a Google executive is now facing murder charges in Georgia. 31-year-old Elise Tichelman, also known as the Call Girl Killer, was indicted on murder charges in the 2013 heroin overdose of former boyfriend, 53-year-old Dean Rio Pele. Tichelman was sentenced in 2015 to 6 years in prison for injecting Google executive Forrest Hayes with a fatal dose of heroin in 2013, but was released last year before being deported to Canada. She now faces murder charges in connection with Rio Pele's death, but denies any involvement. The baby mama of former Jersey Shore star Ronnie Ortiz Magro was arrested after allegedly dragging Ortiz Magro with her car in Nevada. 31-year-old Jen Harley is charged with domestic battery for the alleged incident, which took place with the couple's infant daughter, Ariana, in the backseat of the car. The couple made news in April after Harley posted a video to Instagram of an explosive fight with the Jersey Shore star. Harley is being held on $3,000 bond at the Clark County Detention Center. A popular DJ was arrested in the 1992 cold case murder of an elementary school teacher in Harrisburg, Pennsylvania. 49-year-old Raymond Charles Rowe, who also goes by the stage name DJ Freeze, is charged with criminal homicide in connection with the death of Christy Myrack, whose body was discovered inside her home. Myrack had been violently sexually assaulted, beaten, and strangled. Authorities were able to link Rowe to the murder by using genealogical information that tied DNA from the crime scene to a relative of Rowe. Investigators then set up an undercover operation to retrieve Rowe's DNA from a water bottle and gum he had used. Those were today's top crime stories. I'm Anthony Velez for Law and Crime.
Thank you, Anthony. As always, great stories. Go to lawandcrime.com to learn a little bit more about them. Now, today's broadcast has been brought to you by Hanover Square Press's new book, The Trial and Execution of the Traitor George Washington, a compelling new book by author Charles Rosenberg. It envisions what would have happened if back in 1776 George Washington was kidnapped at the height of the Revolutionary War. It's a really great book, and now we are giving you a chance to win a copy. That's right. Today through July 9th, you can enter to win a copy of the book. There will be 5 winners. Each will be mailed a copy. Readers, you can enter by signing up to our newsletter via the giveaway post that will be published today. Or if you're already a recipient, you can email us at giveaways@lawandcrime.com with the subject line Sweepstakes, the Trial and Execution of the Traitor George Washington. And again, the sponsor of this giveaway is Hanover Square Press. We'll take a quick break. We'll be right back. Okay, so that was the prosecution's opening statement in the penalty phase here in the Quincinio Canada Dwan Malazem case. The 2 men who were found guilty of robbing 3 individuals at a Quality Inn back in 2014. Mr. Malazem was found, the jury was hung on whether or not he had anything to do with Jonathan Price's murder 6 days later or the shooting of Megan Price, his wife. Mr. Canada was found not guilty in connection with the Price assault and murder. So let's talk a little bit more about this with Yosha Gunasekera as we are waiting for them in this quick sidebar. What is the purpose of the prosecution going forward right now in explaining what these defendants have done with their time? They've been convicted felons. What should we gain from this?
They're trying to ask the jury to sentence these 2 men to the maximum penalty. Now, in this opening statement, we're hearing about the extensive criminal history that both of these men have, and the prosecution is making the point that they have been given opportunities, they have been given probation, they have been released from prison early, and they shouldn't be given the same opportunity now.
Do you get the sense that she's a little ticked off, the prosecutor, the fact that the same jury that is going to, the same jury that heard this, she's upset? I mean, I could be guessing, but they can't be happy that they found the defendants not guilty or a hung jury in terms of the Jonathan Price murder and robbery and assault.
Yeah, I would say that she's more than a little bit upset. She's probably spent months or weeks preparing this case for trial, hoping to get justice for the victims, and she wasn't able to do that. So
let's go back live into the courtroom, and we can hear a little bit more. Okay, so that was the defense counsel for Quincinio Canada explaining what the options will be for the jury when they sentence him for these 3 counts of robbery. Let's bring back in law and crime trial analyst Yosha Gunasekera. Is that an effective argument that we're going to show you where he grew up, what the circumstances of his upbringing are? He was 22 years old when he committed this crime. Is that effective? In the sense that he's trying to convince the jury to give this man less prison time.
It's really all he can do at this point. Those are the most positive mitigating circumstances that he can put forth. But I thought what was really effective about this opening was that he spent most of his time breaking down the sentencing for the jurors. So some people say, oh, he's only going to get 2 or 3 years. And the defense attorney said, no, he is going to go to prison, and he's going to go to prison for a long time. And I thought that was very effective.
Saying that, putting that in their minds that this is a young man who will go to prison for a very, very long time. And you heard about these, I want to make sure I get it right, persistent felony offender statute, in the sense that he's been convicted of other crimes and convicted within, I think, a 5-year window. So he could face up to life in prison for this?
Yes, so that statute, if you've been convicted, depending on the number of felonies that you've been convicted of in a certain window of time, that can up your sentencing, and that's very common in most states. So that can be expected to be quite damaging for him if they choose to go that route. But
really, is it effective to say, hey, listen, if he had the worst upbringing imaginable, no matter, where I think they said that we were going to hear from his mother, does that convince a jury and say, well, wait a minute, he's a human being, I understand where he grew up? Or are they more likely than not going to say, everybody makes their own choices, I don't care where you came from, we all have a tough life?
I think it really humanizes him more. And again, there's very little that the defense attorney can really put forward. I mean, they have found him guilty of an armed robbery. And so the defense attorney is going to do everything that he can to sympathize his client.
Okay, Yosha, we're going to jump back into the courtroom because the prosecutor in this case is now listing the record, I believe, for Dwan Malazem. So let's go back live. Welcome back to Law and Crime, everybody. They are reading Quincinio Canada's rap sheet, and it is pretty extensive. But what's the purpose of this? That's right, we're covering this Marine murder case. Quincinio Canada, Dewan Malazam were both charged in connection with the murder of Jonathan Price. Canada was found not guilty. A jury couldn't decide about Malazam. That is in regards to Jonathan Price and also the shooting of his wife, Megan Price. She survived, but they were charged with robbery and assault and also the murder of Jonathan Price. But then they were found, both of them, Dewan Malazam and Quincinio Canada, were both found guilty of 3 counts of robbery that occurred at a Quality Inn 6 days before the Price attack. Now, this is their sentencing phase. What jail time will they ultimately receive? And the rap sheet, the criminal conviction record for Canada, is being laid out. It's pretty extensive, but what's the purpose? I'm here with Yosha Gunasekera. This seems to be a lot, and is this necessary?
The prosecution definitely feels like it is. Again, they want to fully flesh out the extensive records of both of these men and encourage the jurors to not give these individuals, they're saying, another chance by giving them a lesser sentence. So in some way, it's almost shaming them into saying, look, these people have records, they've done terrible things in their past, and you must sentence them accordingly.
And they keep getting out and keep committing crimes, getting out and committing crimes. And according to the persistent felony offender statute in Kentucky, they could receive life in prison, correct? I mean, that is something Mr. Canada could receive. And they said he was 22 years old when he committed this crime back in 2014. But because he committed multiple, felonies right after being convicted of other felonies, he could face the maximum of life in prison.
So the jurors have a lot of discretion here, which is why the prosecution doesn't want to cut any corners. So that's why they're going through this. It might seem extensive and repetitive, but they want to present all the information to the jurors.
Well, we'll have to see what happens. Thank you, Yosha. Let's go back live into the courtroom. We can learn a little bit more of the histories of both of these men. So what you're seeing is a live feed into the Quincinio Canada and Dewan Malazam sentencing phase. They've already been convicted of 3 counts of robbery back in 2014. I'm here with Yosha Gunasekera. How does it work in terms of bringing witnesses forward during the sentencing phase, the penalty phase?
They have a lot of discretion to bring different people. There's certain constraints that you have in a trial that you simply don't have in a sentencing phase. So they could potentially bring a victim of one of his previous crimes in to come in and testify. And it gives that kind of human face and human emotion that you don't really see when she's just reading his past criminal history. So I think this is going to really liven up the sentencing, and it's going to give the jurors something to really listen to.
Well, we know the prosecution will probably call some witnesses, but we also know the defense will as well, as a form of mitigating factors here. Let's go back live into the courtroom right now.
What is your position?
Welcome back to Law and Crime, everybody. That is a live feed into that Kentucky courtroom. 2 men, Quincinio Canada and Dewan Malazam, were found guilty of 3 counts of robbery back in 2014 at a Quality Inn. Now begins their sentencing phase. What will they ultimately face? And as you heard, because they've committed multiple felonies in the past, that will definitely influence the decision about what to sentence them to. And there are witnesses who are being called, both by the prosecution and the defense, to help their case. But is that useful? Is that necessary? Let's bring back in Yosha Gunasekera. So you have this Michelle Blakeman from the Department of, I think, Parole, and I want to make sure I get that correct. Department of Probation and Parole. Why is this necessary after the prosecution just read off all the convictions, the conviction records of the defendants?
Well, as we heard from the prosecution reading off the conviction record, these 2 individuals were granted parole quite a few times. And so we're hearing from this witness to get an idea of who gets parole and a little bit more about the process and shedding a little bit more on the chances that these individuals have gotten. For example, she just testified that not everyone gets parole. It's not an automatic process, and they were given these opportunities, and the prosecution is saying that they squandered those opportunities.
Do you find it surprising that these men have been in and out of courtrooms, in and out of convictions? I mean, and they were able to commit this crime back in 2014. Do you see that a lot?
It's somewhat frequent where people are in and out. It depends.
Is that a problem with the justice system?
Well, it depends on different states. So here, they're getting out earlier and then they're, out and not in prison and jail. That's not happening everywhere. And so I think, there's a lot of issues with the justice system, obviously. Is this one of them? Maybe.
I'm not trying to sit on a high horse here or a platform, but that is really the point I think the prosecution's making here, is why give them another opportunity when they've squandered so many of them. But here's what we're going to do. We're going to go back into court, but before we do, I want to let everybody know that our broadcast today is brought to you by Hanover Square Press's new book, The Trial and Execution of the Traitor George Washington. It's by author Charles Rosenberg, and it envisions what would have happened if George Washington was kidnapped back in 1776 at the height of the Revolutionary War. It's a pretty incredible book, and we are giving away an opportunity for you to get a copy of the book. That's right. From now until July 9th, you can enter to win a copy of the book. There'll be 5 winners. Each will be mailed a copy. Readers can enter by signing up to our newsletter via the Gateway Post that's already been published, or if you are already a recipient, you can email us at giveaways@lawandcrime.com with the subject line Sweepstakes, the trial and execution of the traitor George Washington. This giveaway, again, is brought to you by Hanover Square Press. Let's go back live into that Kentucky courtroom. Welcome back to Law and Crime, everybody. So we're continuing to show that sentencing phase, the penalty phase, in the Quincinio Canadawan Malazam trial. The 2 men who were charged with the murder of Jonathan Price. Mr. Canada was found not guilty. The jury acquitted him on that. Mr. Malazam, the jury couldn't reach a verdict. They were hung as to that count, but they did find him guilty, both of the men guilty, of robbery at that Quality Inn 6 days before the Price attack. Remember, Megan Price, his wife, was also shot through the leg, but she survived. So I'm here with Law and Crime trial analyst Yosha Gunasekera. We talked about it at the beginning, but I want to talk about it as well. The distinction between the jury felt they had enough, or the prosecution presented enough in terms of that robbery at the Quality Inn, but not as much on the Price attack. Is that in part because Megan Price had difficulty identifying the defendants?
I think that was a huge factor, and I really, really credit Megan Price for being honest in this case.
Right.
We know that cross-racial identification is extremely difficult, especially when there is a weapon involved. You're looking at the weapon. You're not always looking at the face of the person. And in that way, I think it was very important that she was truthful, and it really is to her credit.
I have to say, I'm surprised that they were found guilty of the robbery charges, because there was some back and forth about that lineup. There was a lot of questions about the lineups that were presented to the victims in that robbery at the Quality Inn. Some couldn't identify all of them. One victim posted a racist tweet saying that all black people look alike. There was questions about the reliability of the lineup, because one of the tattoos was removed from Mr. Canada's neck because they said that would be too suggestive. When you throw those questions in the air, were you surprised that we saw that verdict?
I was surprised that they were found guilty of that and not guilty of the Prices. I didn't think it would be one or the other. I thought it would be guilty on all or not guilty on all. And you have to wonder, were the jurors trying to split the baby, so to speak? Were they had an inkling that they might be guilty of something, so they decided to find them guilty on lesser charges and not guilty on the bigger charges? As a defense attorney, you're always worried that that may happen, that they're not certain exactly why they're guilty, but they want to find them guilty on something.
And I'm assuming that one of the bigger issues was the fact that the murder weapon, this Springfield .45 that was taken from one of the victims at the Quality Inn, was not found in the hands of either of the defendants, but was found in the hands of a third man, Antonio Fry, who was not charged in connection with any of those crimes. Is that a big issue? Of
course it is. And again, why was Antonio Fry not properly investigated? And I think it lends to the issue that the prosecution could have done a much cleaner job in investigating this case, and the fact that they couldn't get guilty verdicts on the murder charges. I think they only have themselves to blame.
And we'll have to see if they try Mr. Malazam again for the Jonathan Price murder, the Megan Price attack, the robbery of both of the Prices. That will be the question moving forward. Yosha Gunasekera, thank you so much for joining us.
It was great to be here. Thanks so much.
Great to have you. Here's what we're going to do. They are going on a break right now in that Kentucky case, but we are busy today here on Law and Crime. We're going to go to Florida. As I mentioned at the top of the program, we are covering the case of Kwame Richardson and Henry Henry Hayes. Two men who've been charged with the murder of 22-month-old Aiden McClendon, who was gunned down seemingly from gang-related activity, a gang-related shooting. A horrible case about an innocent young boy that was taken way too soon. Let's go live into that courtroom.
And also, the ones previously made by